Welcome back. Like I said, a focus on health law is up next. This is a presentation of attorney Kenneth Haber, who's a practicing attorney in Boyd's, Maryland. Attorney Haber is also well known for his international services. Quite an attorney he is. Today, he's accompanied by attorney Ramesh Khurana, who is the chief attorney and counselor at law at the Khurana law firm located in Gaithersburg, Maryland. On this Good Saturday morning, attorney Khurana has questions for attorney Haber regarding being investigated for healthcare violations. Now that's interesting. Come on close. Let's take a look.
Today I am very pleased to welcome Ken Haber, who is a very experienced and knowledgeable attorney, and he is the former assistant U.S. attorney and a very senior attorney in the office of Inspector General. Ken, welcome to our studio.
Well, thank you. Thank you, Ramesh.
Ken, you are always very kind to answer my questions relating to healthcare issues, and today in fact I am going to ask you questions when there are some healthcare violations and healthcare providers are investigated by OIG, which is your former office, right?
Yes. I was there at the beginning, in the beginning. I actually had permission from my boss, Ralph Guy, who was the U.S. attorney at the time, who became Justice Guy of the Sixth Circuit eventually, to write to Congress and to support the legislation of the IG's office. So I don't think you can get sooner than that.
That's true. And you worked for how many years with OIG?
Well, I left the U.S. Attorney's Office in '79, and then I went to the directly to the OIG. I left there in the end, last quarter of '83, first quarter of
So you are the right person to answer my questions in this session today.
Yes.
Okay. Then explain to us what is the difference between healthcare, fraud, waste and abuse?
Okay. In a prior segment, we had talked about fraud being on one end of the spectrum and abuse being on the other, and that criminal intent.
Now I added two more words.
Yeah, waste.
Yeah, waste and abuse.
Waste and abuse.
Right.
Waste being on the far other end, abuse being on the far other end, and that the intent was the critical thing, dividing those and separating them out, how much intent. Now you got another word, and that's waste in there. And that could easily be even related to government, where the government wastes because they have a bad program that doesn't work. So the Inspector General's office is not only there to ferret out fraud and abuse, but they're also supposed to be there to try to identify waste and how to make the programs more efficient and how to make the programs more economical and give good products for less dollars.
I know you always give some astronomical numbers for waste and abuse. 500 billion?
Well, that's their numbers.
Right?
That's what their numbers were in order to try to justify Obamacare. That's now imploding already because of the fact their rates are going up so astronomically that they said that it was only going to cost so much money. It was going to cost $500 billion, and it was $500 billion of waste, fraud, and abuse. And we can take that out of Medicare, and it won't hurt the programs, and we'll be able to pay for Obamacare. Now, before President Obama is gone, they're seeing that the rates are just multiplying, the premium rates are multiplying astronomically.
And I heard the news that premiums are likely to go up by 25%.
That's what I've heard, and the fact of the matter is you're talking about people who can't afford 25% increase in rates. And what I really resent as a senior myself is that they took it all out of Medicare.
Well, I thought you were very young.
Well, I try to be young at heart, by God's grace. I'm still boxing, but the fact of the matter is that I'm a senior. I put in money into Medicare all these years, and then they take out $500 billion saying that it'll pay for somebody else's instead of the government taking it to the general funds of everybody, and that's what I resent. Helping people is a good idea. It's a good thing to help people, but don't just put it on the seniors. And now to find out that there wasn't enough in the $500 billion is even worse. And the fact of the matter is that you have to scratch your head and say, is there some of that waste, some of that abuse, some of that fraud, maybe fraud on the public when they took out our $500 billion. But the fact of the matter is that they've got to come up with more money, and people aren't running to endorse paying more money. Everyone's saying tax cuts or holding the line, et cetera, et cetera. So no one knows what's going to happen with the Affordable Care Act, people who are getting insurance under that. But the fact of the matter is that it's in dire straits, obviously, and they already took it from Medicare, and there's not much more to take. So I don't know where they're going to get the money from to revamp it.
Okay, great. Let's move on. Let's talk about some of the consequences for violations of healthcare rules.
Well, they can be very, very
serious. I knew
they can be very, very, very serious.
Serious consequences.
Serious consequences.
What are those?
Okay. One of the things on the more mild side is that they can take back the money that you got.
Restitution.
Yeah, they can just recoup the money. It doesn't even have to be called restitution. It's just that the government contractors are just taking back the money. Oh, we saw that you got too much money. We did an audit, so we're taking back $500,000. We're taking back $250,000. That's a lot of money just to have taken out of your pocket at once. So that's a serious consequence. It's not as serious as if there was, like abuse. If there was abuse, which is less than criminal intent, the government could come in with civil money penalties and say, oh, not only are we going to take back the money that you took.
In addition to that, we're
going to take penalties, civil monetary penalties we're going to take from you. And, that can be very, very, devastating for people. I had one of the first civil monetary cases back in the 80s, and it happened that the client had accidentally with a new office manager billed erroneously twice, but it was only twice, 2 big blasts of billings that were erroneous. And we quickly acknowledged it when it was brought to our attention and offered to pay it back, and they wanted to do civil penalties, so we went to a hearing. And after their case at the hearing, the attorney on the government side asked if we still were willing to pay back the money as a settlement, and I said certainly. But they came to realize that it was just accidental. It was 2 times. It was a big blast, but 2 times. It was a new office manager who the boss actually had married subsequently, but it was 2 times, and they didn't have any problems before or after. And because of the fact that they have discernment, and because of the fact that they realized that by the time the first part of the hearing was over, that it was just an accident, they're willing to, to do that. And so they even gave them time to pay it back. So that was nice of them to do that. But that's the civil monetary penalties. And, it's not necessarily every day that they're going to turn around and say, just pay it back. Often it's the penalty, which can be, $10,000 for each line item, plus triple damages for the amounts of each line item. So it can be astronomical without having to show criminal intent. It just shows that these people were being reckless to the point that they deserve some sort of punishment.
But if it is a case of fraud?
If it's a case of open and shut fraud or criminal intent where they can show criminal intent, they can go to jail, obviously, plus everything else.
Plus restitution,
plus,
civil penalties.
Plus exclusion, of course. And the civil monetary penalties could result in exclusion. Now, they didn't impose exclusion on my client because they come to realize through the hearing process that it was actually a good faith mistake and that he was an honorable person.
Now, let's talk a little bit more about the abuse. Now, what type of provider conduct is treated as abuse?
Anything where there's not enough evidence of criminal intent. Well, you know, if there's a violation, they'll treat it as abuse. And as abuse, it can get into civil monetary penalties, and it can get into exclusions. Exclusions can be where people have various, you know, billing problems where there's overbilling, such as the civil money penalties. If there was a judgment against my client that in that particular case that there was wrongdoing on his part, exclusion would come as part of the civil money penalty thing. If a person's convicted of even a misdemeanor, when it deals with the programs, a person can find, well, a person will fall under a mandatory exclusion, not can find themselves being excluded. They will be mandatorily excluded, even for a program misdemeanor. I had a client who the prosecutor was trying to do a favor to because he realized the guy really wasn't a bad guy, let him plead to a misdemeanor, but it was a program misdemeanor. His client didn't realize, and I don't think the prosecutor realized, that meant that there were going to be an exclusion, and there was a mandatory exclusion. Nothing they could do about that exclusion except that they reached out to me, not the prosecutor, but the client reached out to me, and we got a waiver of the exclusion. But there's a whole waiver process that you have to go, and a waiver only applies to a particular locale.
Misconduct. So who has the authority to grant this kind of waiver?
The IG's office, of course.
Oh, only IG office.
The IG office giveth, and the IG office taketh awayeth.
Oh, okay,
I mean,
okay.
Like, but they use a lot of good discretion. I had a case where I fought them bitterly on an exclusion back in the, I think it was in the 80s or 90s, and lost on that, and we put in for a waiver, and we got the waiver. So I mean, like, they're going to exclude them, but you know, you point out the circumstances on the waiver, and they turned around and they waived the exclusion. So,
so Ken, we are just left with about 4 minutes, but I have a few more questions to ask from you. I do not want to miss the opportunity. Now, we did talk about the abuse. Now, let us say I want to ask you a question as to what type of provider conduct is treated as fraud.
That's where the
intent
activity is so evident. The intent is so evident that you know that it wasn't an accident, you know it wasn't in good faith. And when that happens, then there will be a referral over to the U.S. Attorney's Office to seek prosecution, and the IG's office has good relations with the U.S. Attorney's Office across the country. They have good relations with the FBI. They work in tandem with each other, often in task force. I know of one IG cross-designated attorney who works as an assistant U.S. attorney, and she's actually an IG attorney. This is the concept that they had when I went over to the IG's office in the first place back in 79, early 80s, that would have a flying task force where these attorneys would be able to do it. But at that time, there was no push behind it from Congress. So it fell flat on its face because Justice didn't want to give that type of authority to anybody. But in the 90s and 2000s, Congress pushed and pushed and pushed, and now they have these cross-designated attorneys that are actually employees of the IG's office, but doing prosecution, doing grand jury work, going into court and trying cases. So, you know, they're there now. Yeah, no, when I saw her, I said, you know, you stole my job.
Maybe I can ask you.
She says, I stole your job. I said, yeah, that's what I was supposed to do 20 years ago.
Yeah, interesting. So maybe I can ask you just one more question because of the time constraint. Now, what is the process of defining whether or not a provider's conduct is going to be treated as fraud or abuse? Can you please illustrate this point?
Let's go through some of the mechanisms.
You have just 1 minute.
I got 1 minute to explain that. Okay, well, you have a ZPIC, which is a government contractor that's looking out for fraud in a certain geographic area of the country. And there's a bunch of ZPICs covering the whole country. And they come up with something that they think might be fraud. Then it'll go through their process to see whether or not they're going to make a referral to the Inspector General's office. And if they, through their process, they think it's fraudulent, they'll make a referral to the Inspector General's office, and then they'll filter it through their knowledge of what the U.S. Attorney's Office is looking for. Now, if it's just out not of interest to the U.S. Attorney's Office, they'll just close it out and not even refer it over to the U.S. Attorney's Office, or otherwise the U.S. Attorney's Office will be very upset getting all these cartons of referrals. But if they think it's an appropriate case, then they'll make a referral to the U.S. Attorney's Office with an investigative report that they themselves, the IG's office itself, put together using the ZPICS work product or any other federal agency that might come in and give information to the Inspector General's office. Then that's presented to the U.S. Attorney, and they make a final determination as to whether or not it's going to be presented to a grand jury.
Great, Ken. Thank you very much for beautifully answering all my questions. You made me happy today.
I'm glad to make you
very happy too.
I'm glad
thank you very much
for
coming to our studio.
I thank you for having me.
It's always good to have you here. Thank you.
My pleasure.